Ripple winning the case against the SEC is getting more and more obvious, and presently the case could be officially coming to an end. What will be the following decision, and for what reason could the case end by April? Stay tuned till the finish of the video to find out. Welcome viewers to Pianta Crypto. Here we bring you the latest updates on cryptocurrencies. Please hit the subscription button, like my video and turn on notifications so you don't miss our next update. The letter has been submitted by individual defendants Brad Garlinghouse and Chris Larsen in response to the Securities and Exchange Commission's appeal for partial reconsideration and clarification in conjunction with the court's DPP ruling. Toward the start of this month, the offended party documented the hotly anticipated movement asking the appointed authority to overrule her own decision ordering the SEC to turn over drafts, notes and emails relating to him Means 2018 speech, which was viewed not as protected by deliberative process privilege because of the sex assertion that the speech was merely his personal assessment. The SEC is currently asserting that the speech was public guidance, which is a legitimate term. In response to the SEC request, Ripple's counsel stated that the movement was an inappropriate endeavor to do over simply because it is dissatisfied with the court's order on its prior briefing. There's no pretense here that the requesting standard for reconsideration has been met. According to the Securities and Exchange Commission, as an alternative it seeks to diagram a topic that has been intensively argued for over a year once more, however this time on the basis of another theory which isn't almost absolute reversal of the preceding series of events. Ignoring its prior briefing in a sworn declaration it got from former Director of Corporation Finance William Hinman, in which the SEC kept up with that Mr. Hammond's speech simply expressed the personal views of the speaker, a position the SEC presently knows cannot support its privilege claim. The SEC presently argues for the first time that Mr. Handman's speech was the culmination of a policy process inside the Division of Corporation Finance. Mr. Hinman's sworn declaration is in direct conflict with this reversal. By the way, did you are familiar this? Let us know in the comments section down underneath. Along these lines, the SEC presents a brand new 5-page declaration in flagrant infringement of the local rules from someone who has no first-hand information on the issues attested to. Furthermore, does so without seeking permission or offering an expression of remorse. The SEC also at last fails to demonstrate that this court's order of January 13, 2022 was erroneous despite its best efforts. Because of the fact that the court considered and credited both Mr. Hammond's sworn statements in the SEC representations that the speech expressed Mr. Hammond's personal views, the SEC will not be able to demonstrate that the court neglected to consider or credit Mr. Hinman's adduced testimony or the SEC representation that the speech expressed Mr. Hinman's personal views. What's more, the court had already accepted that SEC staff employees had been associated with talks around the speech and had observed that such discussions were merely ancillary to real policy making. Extra argument which could possibly be incorporated inside the SEC self-selected documents, has no impact on the conclusion of the inquiry. According to the DPP, the communications won't be attached since they didn't constitute an essential connection in that specific consultative process, since the conversations appear to have focused uniquely on what should be stated in the speech itself. They were all things considered merely peripheral to actual policy formation, the report concluded. At long last, the SEC protean approach to contesting this issue just underscores why this speech drafts and related communications are important and exceptionally relevant for purposes of discovery to which defendants are in any occasion entitled. Do you agree that Ripple will win this case? In the event that yes, make a point to like this video. The response to the SEC movement from Ripple has prompted Mr. Jeremy Hogan, a partner at the law office Hogan & Hogan, to express his appreciation for the elegantly composed brief that dismantles the several discrepancies presented by the SEC in reference to him in speech, and secondly to express his dissatisfaction with the SEC movement. Wow, I expected Ripple to come out swinging, and this brief didn't disappoint. This is the hardest hitting brief thus far in the prosecution, and rightfully so. The SEC has spun itself a tangled web here, and I don't expect the adjudicator to help them out of it. According to Deed in the briefs, Ripple lawyers are professional and very tactful in clarifying that assuming the court were to accept the SEC new theory regarding the speech that it is the division's perspective, not humans, then the court would be forced to accept that Hammond lied under pledge. The fact that Judge Sharon that Burns, who has seen every one of the documents in camera, will hold the intercession could work in Ripple's favor. Assuming the case goes to intervention, she knows exactly what is in the emails, etc., and assuming that I am correct and that the SEC is the problem child here, that could have a major effect. A decent mediator can really work miracles. Sometimes his best guess is that a settlement will be achieved in April or May, which will be beneficial to the XRP community according to his comments. Comment XRP Army: assuming that you accept the case will be settled by April. What never occurs after that will determine how things will turn out. In anticipation of a judgment by Magistrate Sarah Netburn on the SEC supplication for reconsideration, Ripple XRP holders and the entire crypto community will watch out for the proceeding.